Bismillahir Rahmanir Rahim. Assalamu alaikum. My name is Jalil Ahmed, and today the topic of our discussion is administrative law. Before starting this topic, I have got two statements in my mind. My first statement is that administrative law is basically a human rights law. And my second statement is that while visiting different countries, I have come up with a conclusion that due to lack of administrative law, these developing countries have bad governance. So it is due to the lack of a system of administrative law that there is an increasing rate of corruption. There is so many governing problems. Well, now coming back to my first point, that administrative law is basically a human rights law. Why do I say that? Why am saying that it is a fundamentally a human rights law? We all know that the government holds the power. What type of power? We don't know. Whenever we talk about powers, we always say that the government has the power to wage a war. The government has a power to come into a treaty or into an agreement with another country, or the power to make budgets, or the power to run the economy. But in a greater detail, when we go through with the system of admin law, we will come to know that the government holds tens and thousands of powers. Let's say, for instance, the government has the power to decide whether the insurance is to be paid to an employee or not, whether there is to be an enhancement in the salaries of an employee or not, whether the piece of land can be redeveloped. So they have got numerous power, whether they have the power to decide how driving license is to be issued to a driver. They have a power to decide. They have a power to decide whether the block of land can be rebuilt. They have the power to decide how to grant immigration, etc. They have got numerous powers. And although some of the powers or decisions of the government may be short, they may be temporary or small in nature, but these powers and decisions can directly affect the life of a person. These decisions always affect people, but these decisions are made by the people. Now, who are these people who make the laws? Who issue the directions? Who has the powers? These are usually the public servants. Public servants whose job is to examine the applications submitted before them with regard to any matter. And upon those applications, they need to make a decision and announce that decision. But they are just normal people having a particular job. You should realistically ask from yourself that why they have such enormous powers, and how do we know that they are going to be used in accordance with the law, where they are going to be used those powers properly? How do we know whether they are helping their mates or harming their enemies? Now, because there are thousands of officers making millions of decisions, and any of which can seriously affect an individual, or any individual can become the victim of any of the decision made by a public servant. Now, what is the mechanism that one should not be harmed illegally? Now, here we are. Here we say that administrative law protects the individual's right. So basically, administrative law protects the rights of individual. Now let's say, for instance, if any of the decision is affecting an individual, the admin law sets the rules in which there is a mechanism that if a decision is affecting you, then what is to be done? How to compete this, how to contest that decision, how to challenge that decision, and how to get your redressal if you're an aggrieved party. And then, while challenging that decision, if you have got good reason, if you've got good legal opinions, if you've got good laws, if you've got good logical reasons, then you can set aside that judgment by using the rules set by the administrative law. Now, that's why I say that indirectly, administrative law is a law which is the guardian of the public rights, and individual rights are guaranteed. And this is the area where the developing countries lack. They don't have the administrative law. In those countries where the system is being run by some dictators, some kings, and where there's absolute power and absolute power corrupts absolutely, the decision makers take the decisions, they make the decisions, and the people over there are bound to obey them. The decisions are implemented without taking the considerations of a common man. There is no system of check and balance. A man cannot go against the decision of a policymaker, against the decision of an executive authority. But in developed world, it is very much in existence. People have got the right to set aside the decision made by an executive. And even then, if they are unable to set aside the decision, they have the opportunity to get the proper explanation regarding the issuance of that particular order. So precisely, admin law restricts the government. Admin law stops the government. Admin law gives the authority to a common man to raise his voice against any illegality, against any illegal decision. Administrative law sets out the rules that the government officials must follow in deciding any matter or any application before them. And besides this, it also sets out the rules and mechanism and the policy for a common man. If the decision is unfair to them, if there is any illegality, so there is a mechanism to challenge that decision. So all of these things are due to the blessing of administrative law. Now let's discuss about the historical background of administrative law. Back in the 11th or 12th century, when there were kingships, there were kings everywhere. There was a system of nobility. The rich people, the elite people ruled the entire world. There wasn't any right granted to them, granted to a common man. If you recall your memory, let's discuss about Magna Carta back in 1215, when for the first time the king surrendered before a common man. They started to recognize the rights of a common man. With the age of revolution, Renaissance, the age of glory, when the period of enlightenment started, the people started asking questions, and the rights were being transferred, they were granted to a common man. And simultaneously, while granting these rights to a common man, the system of judiciary established. It was being nourished with the passage of time. During that period of enlightenment, the courts used to exercise judicial powers in the name of the king. Whenever there is a complaint before a court, they used to issue a direction, they used to issue instruction through a written paper. Popularly, it is known as a writ. Writ means it's a written order, a formal order of the court to do a certain thing or not to do a certain thing. There are a number of different writs, but we are very much focused upon these 5 kinds of writ. The first one is writ of certiorari. Writ of certiorari is the oldest writ in the history of these writs. In this type of writ, the court brings the matter before it for a review. In a legal sense, the certiorari is a court process to seek judicial review of a decision of a lower court or a government agency. This writ comes from the name of an English prerogative writ issued by the Supreme Court, where the matter is heard. Now, the second kind of writ is the writ of mandamus. The writ of mandamus, it's also a written order from a court to an inferior government officials, the public officials, ordering that the government official to properly fulfill their official duties or correct an abuse of a discretion. If there is an abuse of power, if there is an illegal act, if some officials are not doing their duties properly, the writ of mandamus is to be issued by the court, directing these officials to do the needful, to do the legal. And now the third one is writ of prohibition. Writ of prohibition means to stop or to forbid, and it is popularly known as stay order. The writ is issued when a lower court or a body tries to transgress the limits or powers vested in it. The next kind of writ is writ of quo warranto, which literally means by what warrants or under what authority. This writ is issued against a person, against an official who is holding the office illegally. The writ requires the concerned person to explain to the court by what authority he is holding that office. And the fifth one is a writ of habeas corpus. Now, the writ of habeas corpus is used to bring a prisoner or other detainee, a person who is confined under some illegal detention. When a person is illegally detained, the writ of habeas corpus is to be issued by the court. In a writ of habeas corpus, the prisoner or the detainee is to be produced before the court to determine if the person's imprisonment or detention is lawful or unlawful. A habeas petition proceeds as a civil action against the state agent who holds the defendant in custody. Well, now these are the writs which are ancient age. These are the oldest writs. Now, this has become the chief method for a common man by which a common man can challenge the government decision, any decision taken by the government affecting any individual's right. They have got this remedy to avail and challenge that decision before the constitutional courts. And now, under the Constitution of Pakistan 1973, the writ jurisdiction is vested in the superior courts. Under Article 199, the High Court has the writ jurisdiction. All the writs can be filed before a High Court. And this power is also vested in the Supreme Court of Pakistan under Article 184, Sub-Article 3, which clearly says that without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, they have the power to make an order of the nature mentioned in the said article. So, let's have a recap with regard to the writs. Certiorari, in kind of a writ of certiorari, the courts consider whether a decision is a lawful or unlawful. Meanwhile, in the writ of mandamus, the court determines and directs or instructs the public officials to do certain job, the job which they are legally bound to do. But if they are not doing it, under the writ of mandamus, the court will direct them to perform their duties in accordance with the law. In a writ of prohibition, the court instructs the government that not to do unlawful. That stops the government from doing an illegal act. And a quo warranto, the court asks from a public official that under what authority you are holding an office. And in a writ of habeas corpus, the court directs to present the accused, the detainee, before the court, and the court will decide whether that detention, whether that imprisonment were legal or illegal. Well, at this point, I would like to highlight a bit difference between legal review and merit review. Now, the courts are bound under this writ jurisdiction. The courts are bound to see whether the decision is lawful or unlawful, despite the fact either it can be a good decision or a bad decision by the executors, by the public officials. The court is not supposed to see the merits of the decision. It is only supposed to see the legality of the decision, whether it is a lawful or unlawful. So this is the difference between merit review and legal review. Under this writ jurisdiction, the court has to see the legal aspect of the decision, respective it is good or bad. As we discussed earlier, that these writs are ancient age, old age writs. Now, in determining and issuing these writs, the courts came up with a conclusion with regard to the legality and illegality of the decisions made by the executives. From time and again, from time to time, they set the rules that what decision is to be legal and which decision is to be illegal. Now, these rules were set by the courts, and out of these rules, the one of the most important rule is the principle of natural justice. Now, according to the principles of natural justice, the first most important is odi altrum partem, right to be heard. Any of the official, any of the court cannot decide a matter without hearing the parties, without giving an opportunity to the party of being heard. Now, along with this rule, which is all about right to be heard, we have another rule, which is known as a fair trial. Now, everybody has a right to have a fair trial. The other one is no one can be the judge in his own case. And along with these, there are certain other rules, such as, according to the principle of natural justice, everybody is equal before the law. Nobody is above the law. The rule of law is for all. Even the makers of the rules comes under the umbrella of the rules. Nobody is above the law. Everybody is equal before the law. Everybody is to be treated in accordance with the law. All are the subject to the law. Everybody should be given an opportunity of being heard. And no one can be the judge in his own case. So these are the principles of natural justice which are very much necessary with regard to the implementation, with regard to the justice. Well, precisely, we may say that administrative law is the body of the law that governs the activities of administrative agencies of the government. And the government agency action can include rulemaking, adjudication, enforcement of a specific regulatory agenda. Administrative law is considered as a branch of public law. And what is administration? Administration is a tool to implement the decisions taken by the executives. And the law with regard to administration, administrative law deals with the decision making of such administrative units of the governments. It is expanded greatly during this 20th century because everything we see today is under the administrative law. So, dear students, today it was the first introductory lecture with regard to administrative law. We started from the statement that basically administrative law is a human rights law. And the second point was that due to lack of administrative law, the developing countries are suffering from the bad governance. We also discussed the writs and the kinds of the writs along being the chief mechanism pertaining to the infringement of rights. I hope you have got the lecture, you have got the points in your mind. If you have got any sort of question, you may ask and you may contact. Thank you.